Good afternoon. So today we are going to be talking about the doctrine of incidental or ancillary powers. What is this doctrine of incidental and ancillary powers? This doctrine states that if a legislative body has the power to legislate a matter on a particular matter, then they also have the power to legislate on ancillary topics, which is related topics to that particular matter, unless that ancillary topic is explicitly mentioned under the jurisdiction of another legislative body. One particular legislative body has the power to dictate or to power to legislate on ancillary topics related to the power that it already had in its jurisdiction. So the concept of doctrine of incidental or ancillary powers determines that it helps the judiciary to determine if the statute made by the legislative body is valid or not, along with the doctrine of fit and substance. Where all the other doctrines work mostly in isolation, this doctrine works with along with the doctrine of fit and substance. What this means is that the authority to legislate on a subject matter includes the ability to legislate on ancillary subjects which are reasonably related to that particular subject matter on which the authority was already legislating over. For example, if the power of the central government is to impose income tax, it would also include the power to examine and seize the property in order to prevent income tax evasion. This includes the ancillary or incidental powers. Therefore, power connected to banking, on the other hand, cannot be extended to non-banking businesses. However, a subject cannot be considered ancillary or auxiliary if it is specifically specified in a state or a union list. For example, pilgrimage is a state subject, but it cannot include pilgrimage outside India, is not ancillary as it is a separate entry in the union list. So what are some of the major judgments in this case? One of such judgment was State of Rajasthan versus G. Chawla, which was in the year 1959. In this case, the Honorable Supreme Court had held that the power to legislate on a topic includes the power to legislate on an ancillary matter, which can be said to be reasonably included in that particular topic. In another case, which is RMD Charbagwala versus State of Mysore in the year 1962, held that betting or gambling is a state subject and it is referred in the state list. However, it excludes the capacity to impose tax on betting and gambling because it is not an ancillary subject matter, because a separate item exists regarding that particular power in the same list. In another case, which was Praful Kumar Mukherjee versus the Bank of Commerce, in this case, the Supreme Court held that in a case, a matter is dealt by the state legislature. If that matter is affecting an item in the union legislature, then according to its true nature and character, which is the fit and subject, such matter should be put in an appropriate list. So what can we conclude by this? By this, we can conclude that the doctrine of ancillary and incidental power, or the doctrine of ancillary or incidental intrusion, is a supplement which is which is added to the doctrine of fit and substance. The main idea or the primary idea behind this concept was that the authority is given to the legislature, and the authority to legislate on the subject matter entails the ability to act on the ancillary matters which are related to that particular subject, to that particular main subject, provided that the only exception here lies is when that subject is already included in another list, another person or another authority is given the power to legislate upon it, then those incidental matters or ancillary subjects cannot be legislated. Thank you.